This video will provide an overview of the hate speech laws in Australia and in Queensland. Under law, hate speech is known as vilification. Vilification laws are one area of laws that impact upon our implied freedom of speech in Australia that we have by virtue of living in a democratic nation. So free speech is not absolute in Australia. We have laws that impose limits on speech that is deemed harmful. So in other videos, we cover other aspects of this, such as defamation law. But in this video, we cover harmful speech that encompasses hate speech or vilification. This speech is restricted because it has the capacity to harm people. So there are laws at both the federal and state level to protect against vilification. At the federal level, we have the Racial Discrimination Act of 1975, and in Queensland, we have the Anti-Discrimination Act 1991. We have both federal and state laws because of our system of government and our constitution. Under Section 51 of the Constitution, the Australian Parliament has the power to make laws with respect to race, but not generally with respect to other characteristics. So for that reason, vilification laws can be made in relation to racial vilification or racial discrimination at a federal level, but the state acts try to fill the gap by extending these laws to other characteristics such as gender and sexual orientation. So let's start with the Federal Act. Section 18 capital C of the Racial Discrimination Act provides that it is unlawful for a person to do an act otherwise than in private if that act is reasonably likely to offend, insult, humiliate, or intimidate a person or group of people, and that act is done because of the race, colour, or national or ethnic origin of that person or group of people. So we can break that down into essentially 4 elements. There must be an act, and an act can include speech. It must not be done in private. It must be reasonably likely to offend, insult, or humiliate. And it must be done for reasons of race, colour, or national or ethnic origin. The words offend, insult, humiliate, and intimidate are taken to have their ordinary dictionary meaning, and I've put those there on the slide. Offend means to hurt or wound the feelings of. Insult is to treat with contemptuous rudeness, affront, or offensive disrespect. Humiliate is to lower the pride or self-respect of or cause a painful loss of dignity to the person. And intimidate is to make timid or inspire fear. And you can see that these are generally subjective qualities. So it's whether the person or group of people are subjectively offended, insulted, humiliated, or intimidated. What does it mean to have a race or an ethnic origin? Again, common sense generally prevails here, but the group must have a shared history and a shared cultural tradition. They may have a common geographical origin, a common language, a common literature, or a common religion, but those are not required. All right, so if you have a matter of potential racial hate speech or discrimination, you can apply the Racial Discrimination Act. You should also consider the state-based legislation. So in Queensland, that is the Anti-Discrimination Act of 1991, and this also applies to race, though it applies to other things as well. So Section 124 capital A provides that a person may not by a public act incite hatred towards, serious contempt for, or severe ridicule of a person or group of persons on the basis of race, religion, sexuality, or gender identity. And again, we can break those into its constituent elements. A public act, again, this can include speech, that must incite hatred towards, serious contempt for, or severe ridicule of a person or group for reasons of race, religion, sexuality, or gender identity. Again, incite, hatred, contempt, and severe ridicule are taken to have their dictionary meanings, but you'll see that this language is a little bit stronger in the State Act than in the Federal Act. Hatred, contempt, and severe ridicule are stronger feelings than under the federal legislation, which was offend, insult, humiliate, or intimidate. So incite means to urge or stimulate to action. Hatred means intense dislike or extreme ill will. Contempt is to look down upon or treat as inferior, and severe ridicule is extreme derision. So the State Act applies to behavior that incites others to feel these things, hatred, contempt, or ridicule about the person because of their race, sexual orientation, religion, etc. Whereas the Federal Act is more about what it makes the person feel themselves. Of the characteristics protected by the state legislation, the most complex one is religion, and what constitutes a religion. And religion has been held to constitute a belief in the supernatural, ideas which relate to humankind's nature and place in the universe. The test for religion also looks at whether the adherents, whether the people, adhere to particular standards of conduct, and that there is an actual identifiable group of adherents to that religion. The Queensland Anti-Discrimination Act, I apologise that the brackets after that heading in the slide are incorrect. This is the Queensland Act. Also contains a criminal provision. So where somebody knowingly or recklessly incites hatred, serious contempt, or severe ridicule of a person or group on the grounds of race, religion, sexual, or gender identity. So this is the previous test, right, for vilification, but they do this knowingly or recklessly, and they do it in a way that includes threatening physical harm towards the people or their property, or inciting others to threaten physical harm to the people or their property, then a person may face imprisonment, and the maximum penalty is 6 months imprisonment. So that essentially makes violent hate speech a criminal offence under Queensland law. There are defences to vilification. They are very similar under both the federal and state legislation. And generally the defense is that something is said or done reasonably and in good faith, either in the performance, exhibition, or distribution of an artistic work. So you can imagine, for example, in a play, it might be necessary for the characters to say hateful things relating to the character and for the reasons of the story within the play. Then so long as that is done reasonably and in good faith, there may be a defense. It is also a defense to do the act reasonably or in good faith in the course of a statement, publication, discussion, or debate made or held for genuine academic, artistic, or scientific purposes, or a genuine purpose in the public interest. So the idea is that this does not completely quash public discussion around things like race and gender identity, but just that speech is not done in a way that will harm others. And the focus on reasonably and in good faith is important here, because this is both a subjective and an objective element to the defense. So whether something is reasonable is an objective assessment, and it requires that steps be taken to minimize the harm that might be caused. In good faith is a subjective assessment, so it is about what the speaker believed, and it requires an honest belief in the truth of their act or their speech, and an absence of ill will or improper motives. So they can't be saying what they're saying expressly to harm others. What happens if somebody vilifies another person? Complaints can be referred to the Human Rights and Equal Opportunity Commission at the Commonwealth level. That will then go through a process of mediation within the Commission, and if it is not resolved, it may be taken to the Federal Court. Similar process in Queensland, but complaints are referred to the Queensland Civil and Administrative Tribunal, or QCAT for short. Both of these systems can award remedies beyond the usual legal remedies, so beyond monetary compensation, and those remedies can include publishing an apology or a retraction, that the person must undertake education or remedial classes to improve themselves, essentially. And those are the laws relating to hate speech in Australia and Queensland.